concludes our presentation.
Madam Chair, may I ask about witness some questions?
Yes, and are the parties planning to cross-examine the witness?
Yes, I do have a few questions, whenever is appropriate.
I'll wait and maybe they'll be asked and answered during that cross.
Okay, thank you very much. So, is it Barron? Mr. Barron?
That's correct.
Mr. Barron, on slide 5, the first bullet. Yes, that's it. It says the project is a result of an Narragansett Electric Company's obligation to connect the CREC to the electric grid. Would you agree with me that National Grid has no such obligation as we sit here today and won't have such an obligation until, as you mentioned at the end of your testimony, all permits are in hand for the power?
Well, we have an obligation to provide interconnection for any independent power producer that's proposed. So in order to satisfy those obligations, we have to do so in a timely manner in accordance with the schedule laid out by the generator. So in order to accomplish that, we need to be doing things in parallel, permitting and licensing, engineering and design, so that the transmission line project can be ready at the time that the power plant is ready.
I understand that, and that makes sense, but you don't have an obligation to connect until the power plant is approved, correct?
It sounds sort of like semantics to me. I mean, as a utility, National Grid is obligated, I believe it's under FERC Order 888, as well as the ISO New England Open Access Transmission Tariff, to provide access to proposed generators that are in the queue. So I see it as fulfilling that obligation. The furthering of this project in parallel with the generator, to me, is meeting that obligation.
But you're assuming that the power plant is going to be approved. I would assume that in most projects that are proposed, that you receive notice of, most of those projects go forward, correct?
Some percentage of them ultimately go forward, some don't.
All right, now for those that don't, you don't actually connect to a non-existent project, correct?
No, we don't. I guess I would draw a parallel to a typical reliability project where, you know, we have to do permitting and licensing, come before this board to seek to do reliability system upgrades, but findings of need, you know, ultimately are with the PUC, and we don't execute the project fully until all permits are in hand, the need's been approved or you know, found to be evident, and then the project moves forward. But we can't do these things in series because we never meet our obligation to connect the power plant in a timely manner. So again, if the power plant doesn't move forward, the transmission line project wouldn't move forward.
Right. I understand that, and that's the point I was trying to make. Thank you.
You're welcome.
Have you done an analysis of the abutters all along the transmission line to determine who the closest abutters are?
We have a lot of experience on this particular corridor, so National Grid built a 345 kV transmission line on the same corridor, the same section of the right-of-way about 2.5, 3 years ago. But in connection with this particular project, yes, we've done, I won't say an analysis to determine exact footages, but we've identified all the abutters. We've actually had door-to-door visits with all those properties. We've established a project website. We've established a project hotline. We've developed collateral materials like a project fact sheet, FAQs, and we actually had an open house in town back in March. So we're familiar with all the abutters and have had those conversations. And it would be our intention to, if the project does get approved and both projects move forward, to have another open house prior to construction and additional visits with direct abutters.
Do you know how many abutters there are?
My recollection is in the order of 60 abutting properties.
Are they all residences or are there any businesses?
I believe they're all residences, subject to check.
Is it the intention of National Grid to offer a property value guarantee agreement to these abutters similar to the property value guarantee agreement that's been offered by Invenergy for the people closest to the plant?
No.
Why not?
National Grid has had this existing transmission line easement for decades. It has existing facilities on it, and it has the full lawful right to the full enjoyment of that corridor. So there's no intention of doing anything differently than we would anywhere else in our network.
Well, you've got the full right to expand that line if this board says so, correct? You can't go expand it without the approval of this board, correct?
We can't do this project without the approval of this board. But what my point was that the existing easements give us the right to the full enjoyment and use of those easements. So the right to construct, reconstruct, maintain, repair, patrol the facilities that are located on the corridor.
The existing facilities. If you're going to expand them, you've got to come here first and get a permit, correct?
Yes, that's correct.
That's why we're here today, correct?
Correct.
And the board has certain things it needs to consider before it decides whether or not to give you a permit, correct?
Yes.
And one of the things it needs to consider is whether or not there's, it's going to serve the socioeconomic fabric of the state, correct?
Yes.
And one of them that needs to be considered is whether or not there will be unacceptable harm to the environment, correct?
That's one of the factors, yes.
And are you aware that this board often looks at what would be the impact on property values in the area, like it's looking at in the power plant side?
I think the question has come up in past cases, but it's at the board's discretion if that's something they want to explore, sure.
But National Grid at this point in time is not offering to the board a property value guarantee agreement for the abutters like Invenergy is on the power plant side, correct?
That's correct.
Could you tell me, you've got, for most of this project, you've got an existing height of the poles, correct? Did you say it was about 85 feet?
Right, so I'll flip to one of the slides here. This is what we call an H-frame structure because for obvious reasons it resembles an H. The typical height of this structure is about 85 foot above ground, but again, that varies with topography and span length between structures. The other type of structure that we're proposing to use is illustrated on this other slide, and this is a monopole structure, so a single pole, and the typical height of this type of structure is 110 feet above ground. Again, that varies.
Right, so that monopole is not there now, that's part of the expansion.
Correct.
And it's going to be 110 feet high instead of 85?
Yes, I mean, that's the average. They would range from 100 feet to 120 feet above ground. And the H-frames range from about 70 feet to about 115 feet above ground. Again, that varies with the span length and the topography along the corridor.
So would you agree with me that this, if this project is built, when it's completed, it's going to be more visible than the existing one?
Actually, our siting board application did contain a visual impact assessment that was performed by EDR, a visual consultant, and their conclusion was that the conditions aren't going to vary much from the existing conditions. There are monopoles like this style in and around the existing Sherman Road switching station. So I guess, no, I don't agree that it'll be vastly, a significant visual change.
Well, that's not the question I asked you, though, was it? Did I say it will be vastly different? No. What I said was, it will be more visible, won't it? Wouldn't you agree with me that, by definition, a 110-foot pole is more visible than an 85-foot pole?
Depending on the vantage point and the topography, yes.
Now, part of this project is going to involve the significant removal of existing trees and vegetation, correct?
Trees, yes.
And those trees are currently, to a fairly significant extent, screening the existing line, aren't they?
Again, I think it depends on sort of your vantage point.
I agree with that. But they are screening the line in varying amounts in varying locations along the 6 or 7 miles, correct?
Sure, they provide some visual attenuation, yeah.
And the removal of those trees will reduce some of that visual screen, correct?
I mean, yes, sure.
Now, will there be additional access points created along the way for either during construction or after the construction is completed? Let's deal with construction first. Will there be additional access points to get into the area?
In general, no. I mean, the existing access to the corridor is from points where the corridor crosses existing roadways. So we would use those same access points to get onto the existing corridor for the construction of the new project, and use the existing access roads that are along the corridor to the fullest extent possible. There will be a need to construct small spurs off of the existing roadways within the corridor to reach the locations of the new proposed structures. But in general, the access points onto the corridor itself would be the same as they exist today.
The new spurs that you'll be constructing, will they be crossing any private property?
They'd all be within the existing easement.
Now, will the work that's being done cross wetlands?
Yes.
Do you know how many? I don't need an exact number. I mean, are we talking about less than a dozen, more than a dozen?
More than a dozen.
I want to object to this line of questioning, and we're getting off into pretty detailed analysis of the project, and there will be opportunities for that analysis in future proceedings.
Didn't you specifically address the permitting required for wetlands in your material?
We did, and that's before DEM
I'll move on.
and the court.
Okay.
Has National Grid done biodiversity studies of the area that's going to be impacted by the change and the removal of the trees?
Objection, and again, getting off into the substance.
It's a yes or no question. I can move on after I get my answer.
Allowed.
I'm not sure what you mean by biodiversity. We've certainly done wetlands analysis. We've done rare, threatened, endangered species surveys, and the sort of environmental investigations that are required to support permits for the DEM and the Army Corps of Engineers.
Okay, do you know approximately the total number of acres that will be disturbed?
Again, objection, Mr. Barrett is not, he's a project manager, but he's not the witness who would testify to these questions, so.
Is he aware of the acreage involved?
Is Mr. Barrett aware of the acreage involved? Mr. Barrett, are you aware of the acreage involved?
In terms of the tree clearing, or?
Yes.
I happen to have a little summary table here, but it was taken from, I believe, one of our applications. So a total of 64 acres of tree clearing. in uplands and approximately 10 acres of clearing in wetlands.
Thank you very much.
You're welcome.
You stated that the estimated cost is $47.2 million, and I believe you gave the certainty estimate, I'm not sure I used the right word, could be minus 25 or plus 50, did I understand that right?
That's the expected accuracy of the estimate.
All right, so it could be as high as, say, $70 million if it's plus 50? Is my math right there?
Yeah, subject to your math being right.
Which is always in question, trust me, I'm a lawyer.
All right. So that's typical for what we call a conceptual grade of estimate. As the project is advanced and the design is advanced, additional estimates will be compiled in that expected accuracy tolerance which we have.
On slide 13, if you could take a quick look at that, please. Yes, that's it. Do you know off the top of your head which of these permits have been applied for in addition to, of course, the one before this board?
Both the Army Corps of Engineers 404 permit and the DEM freshwater wetlands permit were submitted in April.
All right, thank you.
You're welcome.
Have you looked into the town of Burrillville ordinances with regard to noise?
I personally have not.
You testified in response to a question from the bench that, and also in response to some questioning from me, that you are going to move forward with the design, the acquisition of materials, I think you said, even before this board rules on the power plant permit, correct?
That's correct.
And you explained to me why you can't do them in series, you need to do them in parallel. I understand that, yes. Could you tell me what would happen with the investment in the materials and the engineering if the power plant is not permitted? I mean, for example, what I'm getting at is, are the materials able to be used in another project if you acquire these materials before the power plant is permitted and it turns out the power plant is not permitted?
So what we would endeavor to do is to place contracts, for example, for the steel pole structures. And we'd like to do that later this summer. And the reason for that is sort of twofold. We need to reserve the future manufacturing slots to produce those structures because there is a high demand, a lot of utility work going on nationwide and only so many domestic suppliers. But the other reason is so that we can do the detailed engineering. So again, in regards to the steel structures, we need to get the designs from the manufacturers in order to know what the base actions are so that we can complete our foundation design. So it's really to reserve manufacturing but also advance the engineering. And it would be our intention to place cancellation clauses into these contracts so that in the event the power plant were not approved, we could cancel the materials. If it were the case that the materials were actually produced and the power plant not approved, those would be stranded costs that Invenergy would be obligated to pay National Grid.
Because they've got to pay for the whole project.
That's correct, yes.
And what would physically happen? Let's assume you ended up ordering 50 poles, those monopoles, and they were in fact paid for and delivered, but then the power plant did not go forward. Invenergy would still have to pay for those poles, right?
Yes, if they were actually fabricated and delivered, yes.
Right. And who would own them?
I suspect that would be Invenergy that would own those.
That's all I have. Thank you very much.
Anyone else?
I just have just a few questions.
Sure.
Yes, Mr. Barron, just go to the slides on page 9 and 9 and 11, the simulation slides that you have there, you have the views showing the existing right-of-way on page 9. Page 9, for example. I don't know if I got the number. I'm trying to find out for the existing transmission facilities that are already in place on the existing National Grid right-of-way. How long have those transmission facilities been in place there?
The line on the far left is what we call the 347 transmission line. That was constructed in the 1960s. I don't have the exact year. The line adjacent to that is the 341 line, which was constructed as part of National Grid's Interstate Reliability Project. And this line, the 341 line, was placed into service in 2015.
Thank you. And do those transmission lines run the length of the existing, within the existing right-of-way that is the subject of this application for the National Grid portion, 6 miles, I think you referenced?
Yes, both these existing lines originate at the Sherman Road switching station and run the length of the corridor that's the subject of this project, and actually continue all the way into Connecticut.
And those were the subject of the interstate reliability docket, a part of the interstate reliability docket before the board a few years ago.
The 341 line, yes.
Thank you, Dave. Thank you, Mr. Barron. That's all I have.
Anything further for this witness?
I had a couple questions, some of which have been answered. Mr. Barron, on slide 12, just wanted to, the costs. So you said that was the total cost of maintaining the existing right-of-way and with the additional proposed line. Are those all being paid for by, as proposed by Clear River Energy?
Yes.
Okay.
Those are the construction costs.
So there were the differentials that we discussed, that also would all be paid for by CREC?
Yes, all costs for both the construction, but also Clear River would pay for ongoing maintenance and operation of the facility. So even after construction, CREC has an obligation to pay National Grid for ongoing operations and maintenance.
So for that portion of the line, the costs that are currently being paid for by CREC's customers would be subsequently paid for by CREC, or I don't know the right acronym for that, CREC in Energy.
I'm not sure I understand the question.
You're saying that the maintenance of the existing line, which is this right now?
No, I'm sorry, I misspoke.
Okay.
The maintenance and operation of the new line.
Okay, so this is just any costs associated with the new line are paid for?
Correct.
Okay. Also, I just wanted to repeat what was said in terms of the new portion of the line. That's not on the existing right-of-way, would all be, that connector would all be on the property owned currently by Spectra?
That's correct.
The rest of my questions actually have already been addressed, so I don't know if other board members have questions.
I don't have any questions on that.
Could I ask one more?
Sure.
Do you know if there will be any pile driving associated with the placement of the poles or otherwise?
We don't expect any pile driving.
I'm sorry, go ahead.
There's really two types of structures that'll be utilized. So in general, for straight runs where we're not turning an angle, those structures in general will be direct embedment, much like a wood pole out on the street. You dig a hole and place the shaft in and backfill it. for locations where the line turns an angle, or what we call a dead end, and for all the single pole monopole structures, those would be set on a reinforced concrete foundation. So we don't anticipate any piles or anything.
What about blasting?
No.
Thank you very much.
Madam Chair, I'd just like to make one more comment, which is based on how you've described it, you're doing a lot of outreach, and I think that the council for the town has raised some other issues. I don't think they're new issues to you, but that continued attention to outreach and being available to provide information to folks in the community is very important. So just wanted to emphasize that.
Thank you, we agree.
Anything further for this witness? Thank you. Do you have further?
We have nothing further.
Does anyone else have anything to present?
No witnesses here, no?
Madam Chair, I have no witnesses, but I do have some comments about what advisory opinions should be sought at the appropriate time.
Are you going to move your exhibit at this time?
Yes.
Madam Chair, I would continue my objection regarding moving all of the exhibits except the slide presentation, to which I have no objection and can be marked full. As was stated earlier, the purpose of this, I believe my brother, Mr. Watson, said, if I wrote it correctly, quote, not to get into substantive testimony, quote, and he objected a number of times when I tried to even touch on a few substantive matters. Rule 1.9 of the board's rules also makes it clear that the purpose of this hearing is to identify issues, to identify advisory agencies, and to identify licenses that are not within the jurisdiction of the board. And Rule 1.9C deals with limiting testimony in that regard. There is no foundation yet for any of these.
In order to determine any of those things, don't we need to rely on the application and the materials of the application?
We do, and they need to be supported by a witness so that a foundation can be laid for the application before those documents are admitted into evidence. Right now, we have no foundation. We have not had a witness support them. We have not had the opportunity to cross-examine anybody about them. So again, with the exception of the slide exhibit, I would object to them being marked full at this time. I think the proper time for that is at the full hearing.
Is there any reason we can't just, we have the documents for identification, we have them before us. Is there any reason we can't just wait on this question of whether they're marked as full to a subsequent meeting? I'm not sure I understand fully the implications. We have the information in front of us. I don't think they're going to be editing the information that we have, but I understand your objection. I think if they're marked for identification period, then we just put this off for another day.
We could put it up. I don't understand the objection, really. But we can put it up as long as we've got them all in the record. Now, as
Just for clarification, so we would mark exhibits 1 through 1E as ID, and then we would mark exhibit 2 as omitted.
I believe so.
Yes.
We have no objection to proceeding with that course.
I was just going to ask for the sake, but maybe I don't want to put council on the spot. If we've ever been in this situation before, in my experience, we've marked them as full when they've come in, but I'm happy to just wait on it because I don't think there's a meaningful dispute on this. I think we have the information that's available for the parties.
Mr. McElroy wanted to be heard.
Yes, on the advisory opinions, if now is the appropriate time. As I read the filing, it appears that National Grid is in agreement that the town, with the town as well, we agree with their proposal with regard to requesting advisory opinions from the town's planning board, the town's zoning board, and the town's building inspector. However, we would suggest that this board do the same thing that it did with regard to the power plant and ask for an advisory opinion from the town's tax assessor as to whether or not there would be any negative impact on the property values of the various abutters. There are many abutters along this line, 60-some odd abutters, and a similar opinion, in my mind, should be requested from the tax assessor. With regard to other non-town agencies, National Grid and the town agree that the Public Utilities Commission, working with the DPUC, OER, and the Division of Planning, as was done in the power plant case, statewide planning, Department of Health, Historic Preservation and Heritage Commission, and DOT all should be asked for advisory opinions, but the town would request two others. We request that DEM be asked to issue an advisory opinion as it was in the power plant case with regard to the impact of the disruption of many acres along this line. In fact, the amount of acres being disrupted in this matter greatly exceed the amount of acres for the power plant itself. And we believe DEM should be asked what impact on fish and wildlife and their habitat will be caused by that disruption, and what impact there would be on flora, fauna, wildlife, wetlands, etc. In the same way that this board reached out to DEM to basically determine whether or not this project will pose an unacceptable harm to the environment, as it did in the power plant case. And finally, we would suggest that the board seek an advisory opinion from the Office of Energy Resources to determine whether or not the proposed power line conforms to state energy policies, as it did in the last case. Thank you.
Mr. McElroy, you may or may not be aware that generally DEM has not been asked for advisory opinions when it's transmission only. Are you arguing that this is different?
Yes, yes, I am, Madam Chair. As you may recall, this board amended their request for advisory opinions to specifically include, at the request of Board Member Coit, asking DEM to look at what the habitat disruption what the problems could be.
For the plant?
Yes, for the plant. And
Right, but we had already said we wanted to hear from DEM anyway, and typically DEM is always asked for an opinion where there's a plant. I'm just talking about transmission only.
My point is that the habitat disruption of this proposal is much greater than the habitat disruption proposed by the plant. And in light of that, because of the board's statutory obligation to determine whether or not there is unacceptable harm to the environment caused by the proposal, I would respectfully suggest that DEM should weigh in.
Are you talking about the 6 miles of the line that's within the right-of-way that has already been through the process?
Yes.
Presently with the reliability project?
Yes, I am, but we have to, well, of course, there's also the new line, the new correct portion of the line is slightly under a mile. But the reason I ask for that is because right now we have a right-of-way that is only partially developed. And there are many acres, forested acres, on that right-of-way that will be disrupted and impacted by the removal of those trees. And I firmly believe that to determine whether or not there would be unacceptable harm to the environment, we need to take a look at what the impact of that habitat removal will be.
Did the other parties have a position on this? Would you like to be heard?
We object to the request. It's not part of the prior transmission projects, permitting process with the prior transmission projects, including the interstate reliability project that went through this right away and was arguably more extensive than this instant project. That's just with regard to the request to have DEM provide advisory opinion. Also with regard to the tax collector, again, that's something that's not relevant to the instant proceedings and outside the scope of anything that's been done historically for transmission projects. I think with respect to OER, I believe that on the recent Aquinic Island Reliability Project, they were part of the advisory opinion that was issued by statewide planning.
Yeah, I was thinking on that one, and we did that, we've done it before, since the state energy guide plan is part of the state's plan, that perhaps we could just direct statewide planning to consult with OER and have one advisory opinion, but that includes their input on the energy policy.
Yeah, and for that we have no objection.
And I think that makes perfect sense.
Mr. Short, would you like to address the,
Yeah, I think we would join, I think we join the objections the National Grid identified. On the environmental reviews, the permits have been filed, as Mr. Washington or Mr. Barron may have pointed out. The Army Corps and the RIDEM permits were filed that RIPDs, the stormwater, the wetlands. So they're going to be treated within the jurisdiction of RIDEM and receive a full review. It sounds as if there's never been a transmission line requested to DEM for purposes of a advisory opinion, so it seems to be unnecessary here. This is not a completely brand new area that's being regulated, brand new transmission line. It has never existed before. We had an interstate reliability project that's been there for the original. Certainly, it's been there for a couple of years in place. It's received all of its permits. So we would join that objection. As far as OER, defer to the board on the OER a piece of it. I think it's we've seen the OER has been referred for the power plant project, and as we've heard from Mr. Barron, the transmission project is a project that follow from the decision that's made on the power plant project. So it's not an independent transmission line construction process where National Grid is proposing independently. And as far as the tax assessor goes, we defer to the board on that. Again, the interstate reliability project was already been there for a while, as Mr. Barron testified to. So again, there's not likely to be substantial or significant impacts as far as property values go by a project such as this to a project that's already been in place for many years within an existing right-of-way.
what about the,
I'm sorry.
what about the 0.8 mile of new line?
Yeah, no, the 0.8 miles of the new line, we believe that there was that portion of that was captured, at least in in the opinions that were requested by the board, and the wetlands application that was put in will cover that portion as well. And we think that the agencies that you referred, presumably for DEM, for example, that will be we expect that will be contained within their portion of their supplemental advisory opinion.
Madam Chair, I'd like to just point out once again, I don't like to be repetitive, but it was testified that there are 64 acres of trees that will be coming down, and there were, in addition to that, 10 acres of wetlands that will be disturbed. So I really think it's prudent in order to determine whether or not there's unacceptable harm.
Well, the wetlands will indeed be covered by DEM in its work on the permit. I can defer to Director Coy.
Yes, I guess I'll just review the bidding, and in terms of, we haven't been typically asking DEM for advisory opinions on transmission line projects. As noted, we didn't on the reliability project, which was much more extensive. We have asked them in the supplemental, as you pointed out, to look at habitat and mitigation issues associated with the proposed power plant. You do know, and I'm confident in DEM, that in terms of the wetlands application and any other Clean Water Act, there's a 401 water quality cert needed, they will look at fish and wildlife impacts extensively as part of making that determination on, and setting permit conditions. So my thinking right now, I wasn't going into this thinking that we needed to ask for an advisory opinion from DEM because they have these permit and statutory responsibilities that incorporate many of the fish and wildlife aspects, and because we're getting that advisory opinion from them on elements of this for the plant. So that's where my thinking is now. I mean, I think it's something, we're not doing an expedited schedule on this. There's a 6-month period for advisory opinions. So I think it's something we could decide on where we have agreement and put off. I don't know if other folks are thinking, but that's where I am right now.
So again, I understand we have not been asking for the advisory opinion from DEM in the past transmission projects, but are we still looking at will this project cause an unacceptable harm to the environment? So if we are still looking at this issue, so then who will give the advisory opinion on this particular issue?
So every project, we have to make that determination on unacceptable harm. And we would take during the hearing.
Turn your mic on.
The testimony on those issues, and we would be in a position to make it. So I think the question is, do we need additional advice from DEM on that? But we have always construed that to mean the environment, public health, a very broad construction of what's unacceptable environmental harm. So those covers a whole bunch of issues that we'll be hearing from the applicant and the town and other expert witnesses. I hope people could hear me. Apparently my mic was off. I'm sorry.
Just a point of clarification from Mr. Barron or someone who wants to respond. There are approximately 60 abutters, and there will not be any new abutters for the transmission for any new changes.
That number of 60
Approximately.
is approximate from my memory. But yeah, there should be no new abutters. The one new section of right-of-way is that 0.8 of a mile on the Spectral property. That's a very large tract of land that has no direct residential abutters in proximity to the new transmission line. So I think the answer to your question is yes.
Thank you.
we can either go forward with studying the issues and the advisory opinion now, or we can put it over to another open meeting, particularly if we want to look into some of the issues that have been raised. I'll ask my fellow board members.
As far as I'm concerned, I'm comfortable in discussing the advisory opinions that are needed today.
And unless you insist that we have everything entirely completed, I think we could make, and there's a lot of areas of agreement, I think we could make an issue an order on advisory opinions, even if we wanted to revisit a couple of the issues at another open meeting. So I suggest since we're here that we keep moving forward.
Very good. I think we can much of the stuff is statutory anyway, so to list and describe the issues to be considered, as well as the exempt licenses, which I believe there's total agreement, and the advisory opinion is largely determined by the statute anyway, so we can go forward with that. Does anyone have anything in particular they would like to start with? Okay. I believe that this is a list of the issues that we would want to consider at the final hearing, and that's what the statute directs us to do. The first is the proposed facility necessary to meet the needs of the state and or region for energy of the type to be produced by the facility? Of course, the Act applies to all major energy facilities. Some of the language sounds like it's talking about only generation facilities, but it also deals with transmission projects such as the one before us today. Second issue is the proposed project cost justified and can it be expected to produce energy at the lowest reasonable cost to the consumer and capable of remaining consistent with the objectives of ensuring that its construction and operation will comply with all applicable laws, rules, regulations, and ordinances under which, as of the Act, a permit, license, variance, or assent would be required. Or C, does consideration of public health, safety, welfare, security, and the need for the proposed alteration justify a waiver of some requirement or compliance therewith cannot otherwise be assured. Will the proposed project cause unacceptable harm to the environment? Issue 4, will the proposed project enhance the socioeconomic fabric of the state? Issue 5, is the construction and operation of the project consistent with the state guide plan? Those issues determine what agencies and departments we direct to provide advisory opinions. So I was clear from the statutory framework. The first issue, whether the facility is necessary, relies on the Public Utilities Commission with participation from the Division of Public Utilities and Carriers, the Office of Energy Resources, and the Division of Planning of the Department of Administration. The PUC is responsible for for the opinion working with the other agencies.
So maybe just so we can punctuate each, so is the proposed facility necessary? That's the responsibility of the PUC working with the agencies you've named, and so we'll ask them for an advisory opinion that addresses the need for this facility in connection with the proposed new power plant.
Yes, we'll direct the Public Utilities Commission to render an advisory opinion as to the need for the proposed plant, whether or not it's cost justified. And the three other mentioned agencies will participate with the PUC in that determination.
Right, you might have said the plan instead of project, so I.
Oh, sorry.
Record, so it's the need for
Project.
this transmission project in connection with the proposed plan.
Correct.
Just want to clarify, planning is involved because of population projections and stuff. So when you say, is the proposed facility necessary to meet the needs of the state of Virginia? And you say division of planning also, that's because of, they can work on the population projections? Just want to make sure. Must be in there, so this one. It's just coming.
Yes, I think that is.
As we stated before, the Energy Facility Siting Act is a rather old statute, but as we go through it, I think the next issue that you mentioned is it cost justified, and that also.
Your mic isn't
Oh,
on.
I'm so sorry.
No, all of
Okay.
those need cost justified. That's
Right,
all
it's
with the
with the
PUC.
PUC.
Yeah. The socioeconomic impact of the proposed project, including its construction and operation, the project's consistency and compliance with the state guide plan, and in coordination with the Rhode Island Office of Energy Resources, a particular examination of the project's consistency and compliance with the state energy plan. All of that is what the statewide planning program advisory opinion addresses.
And does discuss, so the state planning would give the socioeconomic recommendation, and then in terms of the state guide plan, would work with the Office of Energy Resources to address that aspect.
Since the energy plan is part of the state guide plan.
So on this, when we are saying socioeconomics, we are talking about abutters or in general?
In general.
In general, okay.
The Rhode Island Department of Health would be asked to provide information on the potential public health concerns relating to the biological responses to power frequency, electric and magnetic fields associated with the operation of the project. The Borough Planning Board will be asked to render an advisory opinion as to whether the project would be a land use consistent with its respective comprehensive plan pursuant to the Comprehensive Plan and the Land Use Act. That covers the non-jurisdictional agencies. The jurisdictional agencies. The agencies and subdivisions of state and local government that absent the Siting Act would have the authority to act upon permits, licenses, assents, or variances required for the proposed project are required by the Act to issue advisory opinions as directed by the board and shall act at the direction of the board in issuing the advisory opinion. Those agencies are the Borough Zoning Board of Review to render advisory opinion as to whether the facility would meet the requirements of its respective zoning ordinances and whether the required dimensional variance should be granted, and whether a special use permit should be granted to exempt the project from construction hour restrictions. The Borough Building Inspector will be directed to render an advisory opinion as to whether the work proposed in Boroughville is subject to Boroughville's erosion and sediment control ordinance, and if so, whether Invenergy's or, in this case, National Grid and the CREC erosion and sediment control plan would conform to the ordinance, and whether the project would meet the requirements of other applicable Boroughville ordinances. The Rhode Island Historical Preservation and Heritage Commission to render an advisory opinion as to whether the project would be subject to its jurisdiction, and if so, whether the project would conform with requirements relevant thereto, and whether any required approval or exception should be granted. And the Rhode Island Department of Transportation will be asked to render an advisory opinion as to whether a utility permit under Rhode Island General Laws 24-8-1 and 24-10-1, a physical alteration permit under Rhode Island General Laws Section 24-8-1, or any other Department of Transportation permits are required and should be issued for the project, including construction of transmission lines across state roads or highways. The advisory opinion should specifically consider the potential impacts on traffic and road conditions associated with the project during construction operation.
So that all sounds good to me. I just want to clarify, we have those, they're jurisdictional agencies, in as much as what they provide to us for information will be incorporated into our license in the way of if there needs to be a DOT permit or a sediment control plan. In some instances, as you just mentioned with DOT, we're also asking for additional input on the impact of the project. So I'm just clarifying that we have these, that you just listed jurisdictional agencies where our license will incorporate the approvals that they would otherwise make. And in some instances, we're also asking them for additional input for us to consider.
Correct. We also have to list the exempt licenses. It's all part of what the statute requires for the preliminary hearing. The exempt licenses, which have already been alluded to previously, include the freshwater wetland alteration permits that are issued pursuant to the Freshwater Wetlands Act, Rhode Island General Law, Section 2-1-21. The water quality certification pursuant to authority delegated to DEM by EPA pursuant to the Clean Water Act. And the Rhode Island Pollution Discharge Elimination System permit for point source discharge issued pursuant to authority delegated to DEM by EPA pursuant to the Clean Water Act. Those are really for all the exempt agencies.
Right, I don't, so you listed the state and federal laws addressing water quality and wetlands in DEM's jurisdiction, and then per our notice, we also were looking at CRMC, and I don't believe this is within their jurisdiction. I don't believe there's exempt statutes that we need to list for them.
Oh, that none of the project at issue has anything that CRMC would have jurisdiction over.
That is my understanding.
I believe so. That leaves the question of whether or not to ask for an additional advisory opinion from Department of Environmental Management. We can decide on that now or at a later date. I personally want to do some more research on that, but we can discuss it now.
I really made my, I don't have anything further to add, but I think it would be smart maybe to, if you have further comments, to maybe just hold that off for a later date, as well as the town mentioned the tax assessor. I don't know if you want to address that now as well.
Yeah, we can wait for the DM's opinion later.
I'm sorry?
We can wait for the DM's opinion later, to decide on DM's opinion later.
To decide whether or not to
Yes.
request it. Now, let me be sure, Mr. McElroy, that I have the ones that you discussed. That was the tax assessor, and what else?
Madam Chair, I asked for the tax assessor impact on property values. I asked for OER, but I agreed that referring it to OER to work together with statewide planning made a lot of sense. So to the extent I was asking for a separate OER opinion, I'll withdraw that. And I asked for DEM.
And again, it's correct. I believe that your description of DEM's obligation under the exempt licenses referred to would cover all of the issues that were raised by Council for Boroughville.
DEM's wetland permit and water quality cert will look at wetland-dependent species and fish and wildlife in those contexts. We also have the advisory opinion coming in from DM that's looking at fish and wildlife and habitat regarding the power plant, and to some extent the disruption in the spectra area. I have to look again at exactly the scope of that. That does not necessarily include upland species and forest habitat that's not otherwise covered. So I don't want to state for the record that every single thing that was mentioned is covered, because that's not necessarily so. We will have a hearing where we can consider testimony on that, but I think that's the question, is whether we need an advisory opinion on the clearing of forest habitat in upland areas. And everyone I think knows how important wetlands are for habitat and species, and I think the applicant has made clear, and that's positive, that they're trying to avoid wetlands. And we have special permitting for wetlands because of the importance of wetlands for a number of functions and values. So it really is the upland impacts that I think were being discussed as other areas to consider in terms of habitat and fish and wildlife. Are you comfortable, Madam Chair, with going forward with an order on these advisory opinions where there's agreement? And again, we just talked about a hearing schedule in the first meeting we had today that talks about hearings in the late fall. These advisory opinions will have a 6-month opportunity, so it really will be probably December before, depending if people generally take the time that is given to them. So we're doing these sequentially, that has come up earlier. Obviously, the Invenergy application is the reason that we're here talking about the transmission line. So I'm just commenting on the time period. If you're comfortable with it, I think we could do the order subsequent to this on the advisory opinions we've discussed, send them out, and then further consider the whether there's a need for DEM or to have those issues just covered in the final hearing.
Would DEM have enough time if we were to wait and ask them at a later date, closer to the final hearing?
So as you know, Terry Bray from my staff is overseeing that part, but because DEM is doing an advisory opinion on the fish and wildlife and habitat aspects of the proposed power plant, I do not think it would be a lot of additional work to look at the acres affected under this proposed transmission line expansion.
I think then we should request it as a part of our order today. If they're going to be doing it anyway, it would be helpful to let them know that we'd like some of it put in one section, some of it put in for this. Just to make sure that we have all the necessary information for filing in the appropriate, in the correct dockets. Does that make sense?
So I think what you're saying is that you would want a DEM advisory opinion on the explicit clearing in this transmission proposal. Is that what you're saying?
Yes. And if it overlaps with what they're going to be doing anyway, it seems like it would be helpful to have them consider that simultaneously.
As mentioned, I don't think, given what they're already doing, that looking at the 50 to 60 acres here is a big additional burden. So asking them to look at the habitat fragmentation and clearing associated with this project as part of our advisory opinion is a reasonable thing to do.
Yes, so we should request advisory opinion from the,
Okay, then we will add that to the list. I believe that is everything we're required to address at the preliminary hearing. Is there anything further from the parties?
There's still the issue of the tax assessor's opinion. I don't know if you want to address that now or later.
That, I would like to look at something for that, but if people want to discuss it now, do you have an opinion on that at this point?
no, not at this point, but again, since we are asking for advisory opinion on the socioeconomic features, so maybe we will be looking at the social and the economic impact of the project.
Although I don't think we would include the tax assessor in that particular socioeconomic request. So if we wanted to have specific information from the tax assessor, I think we would have to ask.
I will not ask them at this time. Personally, I would ask them for it.
We can certainly ask at any point.
Correct.
Yeah, I agree. And I think the point was made, it's existing right of way, and I think that holding off on that at this point makes sense.
Anything further? Thank you very much. I believe the hearing is concluded.